Good morning. I'm Gary DeWaal, and this is Bridging the Week for April 11th to 15th, and today is April 18th, 2016. Substantially after the Commodity Futures Trading Commission adopted and implemented similar rules, the Securities and Exchange Commission finally approved business conduct rules as well as requirements related to chief compliance officers of security-based swap dealers and major security-based swap participants. However, the two agency rules are not fully aligned. In addition, the UK Financial Conduct Authority issued a report concluding that, at least in London, there is no evidence that high-frequency traders are front-running other market participants because of speed advantages in receiving order information. Taxes are due in the United States by midnight tonight, so I don't have to be late with my filing. Let's get started. Last week, the Securities and Exchange Commission adopted final rules imposing business conduct standards on registered security-based swap dealers and major security-based swap participants, so-called SBS entities, and requirements related to the chief compliance officers of such firms. The vote for approval was 2-1, with Commissioner Michael Pirwar dissenting. These requirements, which generally parallel but not identical to similar obligations imposed on registered swap dealers and major swap participants by the Commodity Futures Trading Commission, obligate SBS entities to, among other things, confirm that each counterparty is a so-called eligible contract participant or special entity, disclose to each counterparty certain material information about each security-based swap, including material risks, characteristics, incentives, and conflicts of interest, provide information regarding daily marks of security-based swaps, disclose whether the counterparty can require clearing of security-based swaps, communicate with counterparties fairly and in a balanced manner, establish supervisory and compliance processes, and appoint a chief compliance officer who has certain enumerated duties in concluding, preparing, and signing an annual compliance report. The SEC's final rules also address the application of its business conduct standards in connection with cross-border transactions. Foreign SBS entities may also be able to comply with local requirements to satisfy certain of their SEC requirements if the agency has determined that parallel local requirements are comparable and it has entered into agreement with the relevant local regulator regarding supervisory enforcement cooperation and information sharing. According to the SEC, in adopting its final rules, the agency endeavored to harmonize with CFTC requirements to create efficiencies for entities that already established infrastructures for compliance with analogous CFTC requirements. That being said, there are some additional requirements in the SEC regulations that are not mandated by the CFTC, as well as subtle differences in language even where there is an effort to align requirements. For example, the supervisory obligation of security-based swap entities appears more granular under the SEC's requirements than the comparable CFTC rules for swap entities. It was the failure of the SEC to better align its rules with those of the CFTC that apparently was the basis of Mr. Pirwar's dissent. Similarly, the SEC's expectations of CCOs are subtly different than corresponding expectations by the CFTC. Under the CFTC's rules, the CCO of a swap dealer or major swap participant can only be appointed by the entity's board of directors or senior officer. Likewise, only the board of directors or the senior officer may approve the compensation of the CCO or terminate the CCO. Under the SEC's rules, there is no strict restriction on who can appoint an SBS entity CCO, but only the board of directors may approve the CCO's compensation or remove the CCO. CCOs under the SEC regime must also prepare and sign an annual report, as well as perform other enumerated tasks. The SEC's business conduct standards and CCO requirements will be effective 60 days after publication of the SEC's rules in the Federal Register. The compliance date for most of the SEC rules will not occur until entities are required to register as SBS entities. The UK Financial Conduct Authority issued a research paper disputing allegations that high-frequency traders, quote, prey on other market participants and only intermediate trades that would have taken place without their involvement, end of quote. In connection with this, the FCA paper found no evidence that high-frequency traders, quote, exploit their small milliseconds latency advantage to anticipate orders arriving in very quick succession at different trading venues from other market participants, end of quote. FCA concluded that this situation might be unique to London, where all trading venues are within just a few miles of each other. Also said FCA, quote, the regulatory setup in the UK makes it more difficult to predict where orders will be routed compared to the US market, end of quote. However, the FCA study found that there were, quote, patterns consistent with HFTs being able to anticipate the order flow over longer time periods, end of quote. However, FCA was not able to conclude whether this was because high-frequency traders react, quote, more rapidly to new information, quote, or to, quote, order flow anticipation, end of quote. And finally, J. Christopher Giancarlo, Commissioner of the Commodity Futures Trading Commission, again argued in a speech before the Cato Institute that regulators, including the CFTC, should adopt a do-no-harm approach to developments regarding distributed ledger technology, commonly referred to as the blockchain. This is because, said Mr. Giancarlo, the technology has the capability to add great efficiencies to operations in financial services and enhance regulatory oversight over registrants, among other reasons. According to Mr. Giancarlo, quote, DLT developments is clearly moving rapidly, certainly faster than underlying legal and regulatory frameworks, end of quote. As support for this proposition, Mr. Giancarlo cited a successful test organized by the Depository Trust and Clearing Corp just 2 weeks ago of DLT to account on a shared network, quote, a month's worth of trades in the multi-million-dollar single-name CDS market, end of quote. As a result, argued Mr. Giancarlo, government must foster a regulatory environment conducive to the technological innovation needed to address the increased operational complexity and capital consumption of modern financial market regulation. At the CFTC, said Mr. Giancarlo, the agency should revisit its record-keeping rules to ensure they are, quote-unquote, technologically neutral to accommodate DLT. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, get your taxes done ASAP. I'm Gary DeWaal, and ciao.